Let's get started. Thank you, everyone, for joining our panel today. I am Josh Glucoft. I'm a patent litigation partner at Kirkland and Ellis. I'm joined today by Chanley Howell, who's an intellectual property partner at Foley and Lardner. Chanley's practice focuses on a broad range of technology law matters. He's a member of the firm's technology transactions, cybersecurity, and privacy practice, and the healthcare and automotive industry teams. Chanley represents companies in a variety of AI and other technology law areas, such as technology transactions, data privacy and security compliance, software agreements, and digital and online transactions. I'm also joined by Mauricio Paez, partner at Jones Day. Mauricio advises Fortune 100 companies concerning legal issues with digital transformations, virtual data services, global e-commerce, digital marketing, data protection, cybersecurity, technology sourcing and outsourcing, and emerging technology matters such as Internet of Things, AI, blockchain, and Web3, industrial internet, and autonomous machines. He also serves as the firm's Global Data Protection Officer and Cybersecurity Counsel. So this is a panel not about the law itself or the substance of the law, but about the practice of law, the business of law, and how AI is and soon will be impacting it. I recognize that the audience today is probably a mix of outside counsel like us, in-house counsel, and also some folks working in business who want to understand what it is like to work with law firms and to get into law firms. So why don't we start with what we will know best, which is our own private practice. Have you or your firm already started incorporating AI tools into your practice? And if so, what specific tools do you use? If not, how far off is the first meaningful adoption of AI in your practice? And what specific parts of your practice are likely to be impacted first? Let's start with Mauricio.
Sure, thanks. If you don't want to listen about how AI is impacting legal practice, you're in the wrong room. You gotta go to another room. But we are going to touch a little bit about, I think, on, and this is an important question, around how it's the skill set of lawyering is sort of changed internally. As a global data protection officer of the firm globally, which 40 offices worldwide, it's important for me to understand exactly where are these tools and how we're deploying them and how we protect the data and satisfy our ethical and legal obligations. Not surprisingly, a global firm or mid-sized firms have been using AI for a very long time in the practice of law. It's not relatively new. We saw this in the sort of the area of analytics when it comes to doc reviews. This is one of the first applications of intelligent systems. The hot sort of AI platforms of today, like generative AI, those are relatively new. But AI, just generally in terms of data analytics, models around assessing data and creating relational databases, those have been around for a very long time. And so AI in the legal profession isn't new in terms of how it's deployed. Some of them are, and a good majority of them tend to be third-party, so they tend to be third-party services. Lawyers are not coders. We don't necessarily want to build systems and databases. We want to procure those. And so there's a whole sort of area of how you procure these technologies for their profession, which is, in effect, one of the highest standards of confidentiality and security when it comes to information within the practice of law. And we don't, we got a lot of times we talk to folks and say, well, how are you going to use this sort of AI-based system to look at all of this information that we need to look at that ordinarily will take months to do. Now we can do it in a matter of hours. They want to understand how, not just how we're using it, but how is it secured? How is it protected? How to make sure that no one else can access that very sensitive information, particularly when you have a matter that you're working on that is of significant importance. So, AI has been around. The new evolution of AI, like the generative AI or conversational AI, those things are relatively new, even for the legal profession, but there are opportunities to use those. And I think the vast majority of firms like us are looking at those and saying, well, where does this fit within the practice? And not just for internal operations, but in the way that we deliver services. I think for the legal profession, because we're highly regulated, because a lot of issues are abound when it comes to using third parties and using technologies, particularly where you're giving out information for processing, I think will be relatively slow. And we've historically, the the profession has been relatively slow moving because of these ethical confidentiality obligations, secrecy obligations, to adopt these technologies. But I think, like any other industry, it's inevitable because the value proposition is really there in terms of the opportunities for these technologies. And we have sort of three sort of coalescing forces when it comes to how we would adopt these technologies. Certainly is internal efficiencies, cost savings, and operations, right? Those are important. And the evolving skill set, right? I talked about sort of doc reviews. I'm going to use that as an example a lot. Before, you had to have basically an army of associates in the data room, looking through documents and mapping and creating lists and privilege logs and a million things. It takes a lot of time and effort. But that's been reduced significantly because of technology. Even more now when you put on some analytics, some really powerful analytics platforms or AI-based systems. But that's going to change. It's going to take some time as we sort of evolve and sort of figure out exactly how we can deploy these new technologies that were in place. I'll tell you one thing though, and not to get to the end of the conversation here, but none of it's going to replace lawyers. Lawyers are not going to go away. Notwithstanding the earlier program that we had, I would like to not pay my tickets. I think that would be a great idea. But those use cases, those consumer-oriented cases, are very low in the level of complexity. We're talking about areas of practice where a comma makes a difference in a case, right? Your case gets thrown out because a comma was misplaced somewhere. I had a conversation outside where I talked about this issue, and it was everyone surprised that the court just threw out the case because the comma created a very entirely different interpretation. Well, we're not going to get there yet with AI. And even if we have these incredible systems, and firms are exploring them, like my firm and many others, my peers are looking at these opportunities, it's going to take some time before we actually implement them in a way that changes the practice, the skill set. And when it does happen, like it happened in the doc review, it means that yes, there'll be some areas, primarily in the sort of the less experienced lawyers that are just coming out, that tend to get a lot of the kind of mundane stuff, if you pardon me saying that. Some of the routine things that need to get done. Someone has to do it. A lawyer needs to do it because of privilege and confidentiality. So to close out that question, I think we will have changes. I think we will implement more AI. I just think it's going to take a lot more time for the legal profession.
Chanley, how about you?
Sure, thanks. What we do at our firm is look at what we see as the 5 basic use cases for AI in the legal practice. So just to break it down, you have an M&A use case, and I'm sure we'll talk a little bit more in this session about each of these. But M&A doc review, Mauricio mentioned, reviewing what we call in-flight contracts. So a contract being negotiated to be entered into by, in our case, because we're all outside counsel, by our client. Analyzing that contract and using AI to help that more efficient and better. The third is document automation. So if a business team wants to generate NDAs or MSAs or merger agreements, whatever it may be, that can be aided by not just the existing technology that's been around for years and years, but AI is making that better, faster, quicker, cheaper. The fourth bucket that we look at is business intelligence for legacy agreements. So particularly with large companies, they have a very, very big portfolio of agreements, and they want to know what's in those agreements because to date they haven't had the ability, unless they hire an army, to analyze them. But what are the renewal dates? What are the inflation protections, particularly important in this environment? What does it say about limitation of liability? All those metrics that the business team and the CFO team wants to know. What is our portfolio, whether it's vendor agreements or customer agreements? What do they look like? What can we do to improve? So that's part of the AI. And then last is litigation, and that's where Josh comes in. A lot of similarity between the M&A use case and the litigation doc review use case, but all those can be, those are all the use cases, and there's more and nuances. So we focus on that. So I would recommend to you, when you're looking at your own firm, whether it's big law, medium, small, solo, make sure you have the right use case, because the use case can change what AI solution you use, that's fairly apparent, but also how it's implemented. I'll give you one quick example, and then I'll pass it on back to Josh. But in the area of document automation, So creating, let's say something that I work with quite a bit is developing a privacy policy for a website. Yes, there's similarities across the board, but it's many variations depending on industry, applicable laws, et cetera. Perfect setup for document automation and adding AI to that. When ChatGPT came out at the end of last November and it started to get traction, and everybody in industry across the board, including legal no different, said, wow, this is amazing. How can we use this? We got to start using it. We heard I think it was just in the prior session in this room about the lawyer that filed the brief that had cases that were made up. You know, those are examples of people just going too fast, but everybody wants to start using it. So, and if you've used ChatGPT at all, you know, it is pretty amazing. You put in a prompt, you get back a response that is very well written and most of the time based on very good information. But just keep in mind, for example, the use case of generating a document. And exactly to Mauricio's point, we didn't rehearse this ahead of time. A comma can make all the difference in the world. And remember, AI is just trying to predict, the generative AI in its basic form is trying to predict the next word. So a comma is a very small thing, but it did make a difference in that case. And it, as you know, and I think there's mostly lawyers in here, a word or two in a provision can change the meaning completely, or it can make it from an A level, you know, we give it a grade, that provision is an A, but if you change a few different words, it gets us down to a B or a C or not acceptable. And the way generative AI works, as presented in this room just previously and throughout the sessions today, it takes a vast amount of data and analyzes it and comes up with the best response. Well, for a contract, particularly for a complex commercial transaction, getting close is not good enough. And we know, for example, what in our firm, just like these gentlemen's firms, we know what we think an indemnification provision in a particular transaction in a particular context should look like. And while there's some flexibility because of the nature of the English language, if you're looking for the right provision, it's got to have every word in the right place. Generative AI doesn't get you there. It has to be what we call a more curated solution, so that once you can use AI to identify out of the vast majority of hundreds of agreements, whether it's through Edgar, whether it's in your own database, but you can find examples of language. But for when you're going to either generate a document, or if you're responding to the other party's agreement with language that you want, it's got to be pretty dead on. So you need a more curated, human-focused approach, and we will hear all throughout this conference, a human needs to be in the loop. And so that is an example where you can't just take generative AI, spit out a provision and say, okay, this is the indemnification provision that legal chat AI came up with, and so we're going to go with that. It takes a lot more human, and that, again, to Mauricio's point, the lawyers, even the youngest of you in this room, you're not going to lose your job. You do need to evolve with the changing times in the AI, but the human touch is still very much needed, and in particular, depending on the use case. Josh,
I just want to underscore something very briefly, and that's to do with like the human feedback loop. Because that's important, I think, across all deployment use cases, whether you're using it to develop code or to proofread something. The difference, though, is that in the legal world, the fraud on the court is a real problem, and sanctions both on the lawyer and the client can result if you're not actually doing that properly. And the judge is not going to sanction an AI engine you use. They're going to sanction you if you file a brief with made-up cases. So I just want to sort of underscore that feedback loop, that human interaction, is far more important in some areas, and legal is one of those cases where it's really important.
Absolutely. To provide an update as to where my firm is, we recently moved into the pilot phase for both Case Text and Harvey AI, which I think are some of the better known legal specific generative AI tools out there. They are pretty good. I am genuinely impressed, very impressed with what I've seen so far. But to echo some of the statements that my panel colleagues have said, I don't know that any of us are concerned about immediately being put out of business, because there are some things in the practice that still very much do require a human touch. The framework that I've adopted, I think, for trying to forecast how this rollout is going to occur is that I mentally bucket into the 90th percentile and the 99th percentile. There are some things where if you are 90% as good as human, that is basically good enough. And there are some things where you really need to be 99% as good as a human, because otherwise going back and fixing the mistakes embedded by the AI is going to take longer than just doing it right the first time. There is some sage wisdom, measure twice, cut once. And so the low-hanging fruit for, I think, our eventual rollout of tools like case text, for example, really will be in those more triage-oriented parts of the practice, including specifically in doc review, for example, on the litigation side of things, where I do think there is still quite a bit of fat to be trimmed. That's analogous to the data room doc review on the transactional side of things. You heard Mauricio discuss data rooms earlier. I do think that there's still quite a bit of fat to be trimmed there right now. We essentially Mechanical Turk these reviews of hundreds of thousands, sometimes millions of documents. And that is difficult. And that is the kind of thing where we already sort of accept that we are in triage mode and we need to find quickly the top 1,000 or 5,000 documents that may be relevant to a particular case. And so those kinds of triage type exercises that we do already engage in are the lowest hanging fruit. And for those developing tools and systems, it's important to identify, as you do your customer feedback and your research, what are the triage exercises that lawyers currently do, because there just is not sufficient time for a curated, custom, in-depth review from the senior folks on the team. Yes.
Yeah, just a quick question on that. Privacy terms and DPAs are element of great protection, right? In your experience, whether it's productivity or assistance, do you feel like there's enough tools out there to help with the review cycle of some of these terms used? Or?
Yeah. I mean, I'm sure we can both speak to that.
Good group for that question.
Yeah, and just to repeat for the room and also for me, that you mentioned privacy and DPAs, like reviewing DPAs and using, yeah. So my view on that is, yes, there are tools out there right now to do it. Where it exists now is the tools are good at identifying specific topic areas and potentially alerting to language that may be problematic. I would say it's still in early phases, and when I say early phases, I mean it's a accelerator and a partial time saver, but to me the technology is not there, at least on the more common commercially available products, and I'll leave that aside. But it's good at identifying certain topics, certain areas where you would want to focus on. The technology is where you can do some customizing to find, okay, I want to look at, let's say there's 30 potential issues you would typically look for if you're going to manually create a checklist for reviewing a DPA. The technology can add a lot of early on speed to accelerate that and to find it. It can also provide you with language, what we call playbook language, about the specific provision, and model language that could be used to compare against what you're reviewing. So I would say it's very early stages, and I think it's a exciting area where there can be a lot of improvement to add efficiency to the whole process. But it's definitely there. And I'll say for a little later, not that there's any, but I think we could go through, I think just for your benefit, and let you know some of the tools that we use, the commercial tools, just for food for thought, but Mauricio?
No, I totally agree with everything you've said. I'd sort of done what I would say it's probably around the 60-40. You could probably get some, regular, depending also on what side you're in, right? Like if you're on the controller side versus DPAs, depending on what role you play and whether you want to, push your own rather than negotiating ad hoc others that are come in. You could probably, a lot of them are standardized, and where the real talent is on that 25%, where you need some careful thought, a good understanding, what's the nature of the processing, stuff that the AI tools may help you think through the issues, but not going to give you like that decision that you're going to need when it comes to what is the position I'm taking and how do I want to be consistent. So I think there's still a lot of room left for more development in that, and it's exciting times. I totally agree.
Yeah.
I think there are opportunities, not just in DPAs, but in other areas, policy development, protocol development, the more omnibus, globalized kind of transfer arrangements that have some of these DPAs embedded within it. So there are, for those that are not in the privacy world, I apologize. But there are, like any other areas, opportunities where there are some good standardization that you're going to sort of can live with, and there's still a big piece that requires talent, skills, analytics, a real good thought on the legal front. So it's not going to change anytime
Yeah,
soon.
and I would just add real quickly, it's very good at identifying what's not in an agreement, DPA or anything. It's very good at that. It's then next good at finding, okay, here's the 30 issues we're looking for, and here in the agreement, you can quickly go to it, at least what the AI has found. So for adding speed that way, and then adding some playbook, but otherwise, like Mauricio says, pretty much at that point forward, you're quote on your own, and you got to use your legal skills to get it to the right place. Yeah.
So I am not a privacy lawyer. I'm a patent lawyer. I will certainly defer to my colleagues on the privacy-specific piece, but I think generally one takeaway, again, for those working on tools and products for the practice of law is that because no single tool is necessarily 100% good or maybe even ever going to be trusted as being 100% good, I think in many niches there's room for multiple winners in any given space. So for example, even in doc review, or data room doc review, you may feel like one model is better at detecting sarcasm than another model. And so in those situations, I think it's very possible that we routinely roll out multiple tools to try to reduce the number of false negatives. This is sort of like a Swiss cheese type model, to borrow something from Peter Attia. I think the notion that if there's a tool that's 60% good at catching false negatives, well, let's layer on top another tool that's maybe 50% good and another tool on top of that that's maybe 40% good. And the hope is that nothing actually makes it through that complete gauntlet. And so this is a situation where, because lawyers are so risk averse, and because especially I think at our end of the market where the cases and the deals are so big, there is willingness to pay to make sure that these tools actually do the job to a degree where we are comfortable putting ourselves on the line, right? A single mistake can potentially blow up the firm. So we are extremely careful with anything we roll out, anything that's not being manually reviewed by people in the know. Question in the back. I'm sorry, what's the general philosophy for firms on building versus buying?
Oh.
Sure.
That's very kind of you, by the way, to say it's not the most innovative.
Not the most.
It's not the most. Yeah, thank you for that. I would say that I will start on this sort of answer, but as I was sort of noting before, I think that law firms are inherently risk averse, but they also don't invest heavily in technology development. That's just the reality of even for the largest law firms. Now, the largest firms do have a lot of, like my firm, significant technology groups and investments, and we do developments, but these are not developing entirely new applications that we'll think will make our business transformative, that it will change the way we do business. We still heavily rely on third-party technologies. We get customizations, we isolate them, we have to, right? Because there's three things we haven't really talked about yet, but this is the constraint for how many of you are lawyers in the room? By show of hands. Right, so our lawyers are gonna sort of, we won't get too into the weeds on this, but generally there are three principles of legal ethics, which really it makes it very challenging adopting, not just developing, but also licensing technologies or technology services. The one is the duty of confidentiality, right? We're just not allowed to disclose confidential information to any third party without the client's permission. If you're using a system and environment that then takes some of that information that the client might consider to be something that is just theirs and is confidential to them and it should not go anywhere else, that could be a problem if you're using an open sort of AI tool that results in the prompts going into a database, right? We saw some cases where there was litigation because someone put confidential information in the generative AI engine. And all of a sudden, it went out in the wild. So that's a big sort of issue. The other one is our duty of competence. That means that we don't have to just be competent in terms of how we provide legal advice, provide legal services, but the manner in which we provide our legal services. And all ethics rules all over the country says that includes how we use technology. New York being the first state that adopted an expanded rule that requires ethics credit for cybersecurity for any technology used by any lawyer that's licensed in the state. And if you don't have that one ethics credit, you get your license pulled, right? Because I realize it's important to understand that competency isn't just in the way you provide legal advice, but how you're providing the tools that you're using. And the other is the obligation of supervision, right? This is intended to be supervising young lawyers, clerks, others that are supporting the provision of services, or forensics providers that you hire as a lawyer in order to support the delivery of legal services. You're supposed to be adequately supervising. Well, it's difficult to do that if you're relying on an AI system to do that. So the ethics really makes it complicated. It's not unsurmountable. It doesn't mean you couldn't do the things, you couldn't adopt these technologies. We've given you a number of examples where we were able to adopt these new technologies that are AI-based. But it requires a lot more thinking, careful thought, careful decisions. And look, to the point that we were making earlier, there are opportunities for efficiencies. There are opportunities for savings. And I think it is appropriate as in-house lawyers, as the client, to ask those questions. How are you using this? Not only just because you want efficiencies, but you want to make sure that your information is protected. This very secret information, confidential information. How do you make sure that you're not generating outputs that can constitute bad advice, right? So those are really important sort of considerations that all law firms go through. Unfortunately, because just it's inherent that we have sole practitioners that have less time to think about technology and security, and you have large law firms that spend a lot of time and effort and resources to think about these issues. And so you will see a very spectrum of difference of approaches, I think.
Yeah, on the buy versus build part of the question, I'll do something lawyers don't usually do and give you an unequivocal answer. In my opinion, is to buy, don't build. Whether you're a solo practitioner or big law. I've been on our firm's technology or innovation committee. It's gone through various name changes over the years for over 20 years, and I've seen it all. And particularly in today's world, in this environment, definitely buy. You don't have to buy big. You don't have to necessarily, in these days it's hard to get, OpenAI or Microsoft's attention for a truly customized or bespoke solution. But I would stick on the more mature end of the spectrum. And that helps you not only it certainly helps you on quality and maturity of products, but it also helps you on, more often than not, on pricing. A lot of times we think smaller is cheaper. It's not always cheaper, and very often in this environment, it's not as good. So that would be my advice.
And so I'm also in the buy camp, and I think that there's at least two important dynamics that are driving that. One is really the hive mind mentality, especially among so-called big law or the AmLaw 100 or AmLaw 200 firms. If Jones Day or Foley have some tool that make them better at being practicing lawyers, you better believe Kirkland is going to have that. We're not going to give up that edge. Why would we be penny wise, pound foolish? And so when you get your foot in the door with one firm, a lot of the other firms, they pick up their heads as well, because we all want to have every tool at our disposal to be the best lawyers that we can. We don't want to be disadvantaged right out of the gate. So if one buys, the most, maybe all of us will end up buying, I think, for that reason. On the second big factor is recognizing that there's a difference between the data layer and the technology layer that sits on top of the data. And so we as law firms and lawyers can still compete and differentiate and provide a clear added value by bringing our unique knowledge, regardless of whether we have some slight, very difficult to quantify edge on the technology. And so that's another reason why I think we are happy to outsource or buy really the technology layer, because where we really compete and differentiate is the proprietary knowledge, having worked on the deals, especially that this is something that the transactional lawyers benefit more from, because the deals are not public like litigation is. So differentiating at the knowledge, at the data layer rather than the technology layer is, I think, probably the long-term moat for law firms, and one reason why we are more willing to buy when the tools really are working well. And we'll take, I guess, one more question if we've got time for it. Yeah. Glucoft, Glucoft. That's correct, yes.
So I just interviewed an ethics professor who said that any firm that is not using AI 5 years from now will be subject to both competent or incompetence and malpractice claims. What are your views on that? And do you agree?
Yeah, so I'll just quickly say, when you think of a stereotypical lawyer, there's a big wall of books behind the lawyer. And I would say that any lawyer using books is borderline committing malpractice at this point. And so there's no question that AI and the intelligent, competent use of AI is going to be required. I think what level of adoption, which tools, what pieces of the practice are required, that is very much up in the air, but would love to hear your thoughts.
Yeah, I completely agree with that statement, and it was basically, just in case you didn't hear it, if in 5 years lawyers aren't using AI, that's going to be a violation of your ethical duties. I agree, and it does depend on the use case. When the three of us were chatting before this and preparing and talking about different topics, one of them was, what are the risks you see ahead for AI in the law? And the first one that comes to one's mind typically is relying too much on it or implementing too fast or that type of thing. And I agree with those sentiments, but when I was coming up with my own list, I was making a list, and then I found myself at the end putting at the top, not using, this would be for now, just not for 5 years from now, but not using AI enough is, I think, a very real risk. Again, no matter what the size of your firm is, if you're not using it, not that you're necessarily in today's world violating your ethical obligations to your client, maybe you are, but you're not providing your client appropriate services, you're not using the technology and the tools that are available to service your client. So to me, a big risk in our profession is not using AI enough, not learning about it. Mauricio talked about the ethical obligation to know the technology, and that means not just if you're faced with technology and e-discovery in a court case, knowing how to do e-discovery. In my view, it's also not getting on the bleeding edge, but using the tools that are out there and available. And so if you don't use it, even now, I think that's a risk of all sorts. Mauricio?
I would say, I think my co-panelist answered the question. I'll give you a very lawyer response. It depends. But I would say one thing, though, when it comes to the procurement, a law firm should approach the procurement of these sort of new technologies as you would expect a financial institution. to approach it. Heavily regulated, heavily risk adverse, a lot of requirements, a lot of due diligence, a lot of protections. So you may find other industries that are more flexible, less risk adverse, probably more willing to do pilots and try things out, see how it goes. You're going to find that there are some firms that are willing to do that around some pilot areas, but generally speaking, negotiating and implementing and then using a system requires a lot of discussion, negotiation, and selling to the firm. Because, unfortunately, to the point that was made earlier, the truth is that firms do rely heavily on provider products and services. But once they do, they stay with them for a very long time. And it's very difficult to get firms to move, as you've been in the technology community can attest to, I'm sure, to move from one thing to it takes a while to test it out, conduct due diligence, because we, as, again, going back to ethics, lawyers have an obligation to ensure that when we procure a third party to provide services or tools that we're going to use to provide services, that they have to meet the highest standards of confidentiality. And we have to make sure we go through that process. So for those of you who are interested in going to the market, to the legal market, and start pushing a lot of these tools, be prepared for this sort of very lengthy process, because I just think that that's inherent. Now, there may be other tools that are easier to adopt, try out, pilot. I'm not talking about those. Those are just run-of-the-mill. I mean the ones that are really going to be adopted as part of the operations of the firm in the way that they deliver services.
When it comes to, sorry, go ahead.
No, go ahead. If there's time, there's a question over there, but please continue.
Yeah,
Josh.
let's get one last question in. Yeah, so the question, just so everyone could hear, was about how you basically leverage the client data that you have for purposes of training. This is a difficult question because you may have cases, deals over the last many years, but those clients did not consent to have their data from those prior years used in your training model. In addition, obviously, especially for multinational law firms, which at least Kirkland is, there are going to be GDPR and privacy hosting issues. We can't necessarily just bring the data over in order to train our models. These are questions that I think even I would love to hear, Mauricio, your take on it, but I don't think these are questions that are solved. And I think the good news for folks still trying to get in is that because it is so hard to retroactively leverage that prior knowledge, it's more of a kind of bootstrapping. We're doing it along the way. It means that maybe there is still some room to get in, but Mauricio would love to.
I agree with that. In the interest of time, I don't want to add too much to it, but it requires a client conversation. There are some clients for large law firms that, where the opportunity might be there to focus on a handful of clients where you can, talk to them about this opportunity, that there's value for them as well, right? And so that you could perhaps develop a pilot program. But I completely agree with Josh. It's a very difficult thing to do for historical stuff across the board.
Yeah, and I'll answer. I'm working on it, and when and if I figure it out, I'll let you know. That's how hard it is.
Thank you, everyone.
Thank you.